of new legislation. What we plan to do today is talk a little bit about SB-91, get everybody up to speed on what's happening with that and some of our experiences so far. Talk a little bit about some of the commercial issues facing commercial owners as it relates to evictions and moratoriums and some other legislation that's probably not too favorable for landlords. And then talk about what some of the options are. We've spent a lot of the last year, Jason and I, working with a number of clients who have looked to see other opportunities. And we're going to walk you through some examples today of the numbers and why it makes sense for people to consider it. I think it'll have some similarities to a lot of you that are joining us today, and maybe it inspires you to take a look at what you can do. But Jason, why don't we start with giving everybody a quick recap of what SB-91 is, and we'll kind of take it from there.
So SB-91 is the extension of AB 3088, which was the state's bill on the eviction moratorium. The benefits are, well, first it extended AB 3088, which required from September of 2020 until June of 2021, all renters to be eligible for protection to pay at least 25% of the rent. And starting July 1st, landlords, as of now, can file for breach of contract for the money owed, but it's consumer debt going forward. And then you can start filing for unlawful detainer evictions starting August 1st for rents not paid in July, so long as the people have complied with the 25% payments. And then what it really did was put in place a program, Justin, where people can apply on behalf of their tenants to get back 80% of any back owed rent. So we're actually going through this right now in LA with a tenant. It's 80% of the 100% amount that wasn't paid from March until September 1, and then 80% of the 75% between September 1 and June 30.
Go through those two numbers one more time so people can understand what they can expect to get if somebody qualifies.
So if someone qualifies, you would get this. You would get any rent missed between March and September 1st. You get 80% of all of that rent. So it could be up to 100% of the rent was not paid. You get 80% of that. Now, between September 1 and June 30, you get 80% of the 75% that hasn't been paid, because in order for a tenant to be eligible for the program, they have had to have paid 25% of the rent from September until June.
All right. Is the slide up on the screen?
It's not showing up.
Okay. Couple things that everybody should also keep in mind about SB-91, and we'll talk about them in a minute, is one, the state was allocated $2.6 billion in relief funds that are being distributed either by cities, counties, or the state, depending on the municipality's election of how to do it. To give everybody an idea, there are 4,921,000 rental units in the state of California. So real quick, if there was relief being provided to every unit, the funds provided to the state of California would provide $521 of rent relief per unit in the state. A couple things though.
Justin, is that for 1 month, or would that be for the entire time period?
I think when you do 2.6 billion divided by close to 5 million, you get $521.
It's 1 month. That's my point is it's not even enough to cover probably what is a third of the average rent for 1 month for most people in California.
Certainly, at least in the areas where a lot of our clients own in Southern California. Then a couple other things about SB-91. There's a priority list because obviously $521 per unit in relief isn't going to help anybody. The first priority is communities disproportionately impacted by COVID-19. The second priority list will be eligible households with a household income that is less than 50% of the area median income. Jason will talk a little bit about area median income and how to manage that in a minute, but that number in LA County is $38,650 in LA County for a household of 4. Orange County, slightly higher. And then the next tier of priority is eligible households with a household income that is less than 80% of the area median income. And that's going to be $61,840 in LA County for a household of 4. So keeping those numbers in mind, we start to look at and go, all right, well, who's really going to be able to get this money, and how is that process going to work? Jason, can you talk a little bit about, is there any clarity on how many applications have to be received to determine who qualifies, or is there a window of time? What's the process of how it's going to be determined?
So I can talk, let's first talk specifically about LA, city and county. So the county is, HCID LA is administering the program. I've actually gone through the process all the way already with, for a client with a tenant. So I can kind of talk specifically to that one first, and then we'll expand. So LA released their program a month later than everybody else. So that's the first thing. And LA thinks that they're going to run out of money at the 50% AMI level. And so they actually did a lottery, and you had to submit your application. We got ours in the very first day. We were selected in the lottery. Once you find out you're selected, you're given 10 days to fill out another set of paperwork and get that back in. If you don't get that done in time, you're then uneligible again or go to the back of the line. So right now, LA is doing it on a lottery basis. And then the state, my understanding, the way the state was doing it was as in order of applications received. But, with the way things are working, how backed up places are, the applications might not be received timely. It depends if they were mailed in, how they were sent in, and how they're then processed by the people that are administering the program. But LA is a full draw. And the LA application was done fully online by our tenant actually as well. The first portion, the second portion was a paper portion.
Okay, so a couple questions as it relates to that. Just in LA, can someone still apply?
Yes, the applications are still open. I'm just not, and they're still working on them. I'm just not sure if they're filled up yet.
Okay. And next question, you had said that the tenant has to go out and fill it out online. How easy was that for your owner to get the tenant to do that? Did the owner step in and help? Anything like that?
So we reached out to the tenant directly and said, we would like you to apply for this. It will get rid of a majority of the money you owed, and then it wipes out the rest. The tenant jumped at the opportunity because they saw it as free money and money that it erased the debt that they would have to owe. So they were on it. We didn't have to really encourage them much. I did make myself available, and the tenant did call me 2 or 3 times during the application process, because the tenant was actually very concerned about making sure every I was dotted and T was crossed and the numbers were even correct, because she didn't want her application rejected.
All right. And then as Jason mentioned, we were, in talking about, and Jason, I'll let you make some more comments on LA if you have them in a second, that in LA and Orange County, Los Angeles, the city of Los Angeles and the city of Long Beach have their own programs. The rest are using the state program run through Housing and Community Development. And then in Orange County, Anaheim, Irvine, and Santa Ana have their own programs, while the rest of the cities in Orange County are using the county program. Jason, any additional comments you want to make on the experience in LA so far?
We did a piece of paperwork wrong on a different one, just slightly, and we got an angry letter from the RSO office. So make sure your numbers are right in LA. They actually sent us an angry letter that we had to rescind our paperwork and then resubmit them the correct ones first. So I would say just be careful in LA. They're really, really focused on making sure things are perfectly correct. I've heard much better experiences people are having at the state level and the county level. So.
All right. Couple other things as it relates to 91, and then we'll move on. What can owners, give us the dates of when it applies again for everybody to understand.
So the tenant did not have to pay any rent from March until September 1st. And then from September 1st until June 30, they're supposed to have paid 25% to be eligible for the program. Now, there's one thing to keep in mind is at the time of the application, they would have needed to have paid 25%. We've talked about this in the past, Justin. The way the law reads is if someone came on June 30th and gave you a lump sum check for 25% between September 1 and June 30, it's likely the court would allow that as a payment, but that applicant wouldn't be eligible to apply for the program until they made the payment. So keep that in mind.
Sounds like a bunch of hurdles. Where can someone get the app?
HCID LA's application is right on their website. Actually, usually when there's a normal HCID LA landing page, now the landing page is the actual application page. And then there's different websites. I think somebody actually posted one, Housing is Key. I think it's on there. It's also on the state's website. Someone posted one in the chat. But that's where the applications are, the ca.gov for the state level one. And then the counties, just go to the county housing authority website or the city specific housing authority website. It's usually the first thing in big bold letters.
Okay. And since you're reading the questions, what proof do the tenant need to provide? And talk about that with the tenant that you worked with, one tenant who you thought maybe before COVID was making more than, let's call it, the area median income, but they were still able to get approved.
Right. So the first thing that we had to do is we had to, as part of the landlord's job on the application process, was we had to show the COVID paperwork that was required. So we had to show that we gave the tenant the paperwork regarding the COVID hardship. They had to fill out the hardship declaration. Within the hardship declaration, you have to make sure your rent numbers are correct, how much has been paid and how much is still owed. Because if those are wrong and they figure out those are wrong, then you get, essentially it's government fraud. So you don't want to do that. So we had to turn in those items for our tenant. My concern originally was, as you said, Justin, she made well over the area median income in 2019, but she completely lost her job in her business in 2020. She made next to no money. I think she made $15,000 total. We were fortunate that she had already filed her tax return, so we had those as backup, but we weren't asked for those yet. So as of now, it's self-certification, but you need to make sure that when people check the box that they can prove that. But if people fully lost their jobs and actually couldn't afford to pay, it'll be really easy to prove if it's ever questioned, but we did not have to provide that right away. We just had to, with the declarations under penalty of perjury, so that counted.
Okay. Thank you for that. It certainly seems like a fairly complicated process. Jason, you're a real estate attorney and you're getting involved in helping somebody navigate the process of SB-91. Maybe talk a little bit about why you think your client engaged you to help them through the process and didn't just try to go it alone. I mean, you've given me 7 different reasons already of why it would be valuable, but talk a little bit about the desire to engage you and what issues at least the client foresaw that they saw value in bringing you in, because maybe even just talking about those issues will help some owners avoid some headache as they go through the process.
So the first reason, and I would highly recommend this if you're in any city that has rent control, is the RSO regulations are so strict that if you do something wrong, you're going to get at least a slap on the wrist, and they might do more just because you made a small mistake. So having us help you get it right and make sure it's right is important. The second is, if your numbers are wrong, if the application's wrong and you get paid too much money, it could be considered fraud, as these are government funds and there's a specific formula for you to get the numbers. So those are the 2 big reasons, and just navigating it. Having gone through the process now, I can do it 5 times more efficiently and make sure that the tenant gets it right. I went through, like, literally screen shared at one point and walked them through the application so I can know exactly what it looks like. We make sure we get it right. Because if you do end up going to the back of the line and the money's gone, you're not going to get the money at that point in time. So
let's talk a little bit about the money. We just went through the numbers, and $521 a unit seems pretty, not enough. I believe there's a stat out there that says approximately 20% of renters have missed at least one payment in the last 12 months, which, if that's the case and only those people were under hardship and received relief funds, that would only be $2,614 per tenant who's missed 1 month of rent. So again, maybe 1 month, 2 if you're lucky. Well, maybe not if you're lucky, if your rents are low, but maybe 2 months worth of coverage, and that's just giving it to the people that are already, that have missed a payment. But What do you know about any future additional money that'll be available to? Have you heard anything about that? And then I'll ask you a follow-up question about April.
Okay, so I haven't heard anything yet about additional money, but this is not from the most recent stimulus plan, this money, but it was from the prior stimulus plan. I can look in and see if there's more money coming for it. I will tell you that when we filled out the application, my client was owed somewhere in the neighborhood. The rent was roughly $3,000 a month. We didn't get any payments from March until September, and then we got roughly 30% of the payments from September till May. The reason I say May is because we bought the tenant out. We did a cash for keys right after we got them to submit the application. And the total amount owed was roughly $40,000, and we're expecting to get a good portion of that. We're expecting to get 80% of that. So to your point, Justin, with the $2,000 a door for 2 months or whatever it is, like we just took 40. So that's, 20 doors that are now covered by what we just did. And that was just one tenant with one application. And so I think that there will potentially be more money coming. They need more money because there's not going to be enough to cover everybody. But at the end of the day, there's not a blank check that they can write either. So at some point, they're going to have to make a decision to stop.
And what about April, May, June of 2021? There's still, tenants can still pay the 25%.
Right.
There's still eviction moratoria in place.
It's a catch-22 because in our situation, if tenants just paying 25% every month, you want to get your application in now to get the money for the back owed rent. But at the same time, you might not get the 80% of the 75% for, let's just say, April, May, and June if you got your application in at the end of March. So the question becomes, and nobody knows the answer yet, what's going to happen to that 75% delta for the 3 months? If there's more money that comes out, I would assume that they would allow you to buy or to reapply, for the last 3 months, but we don't know that answer just yet. So I would say if you're planning on applying, do it right now and try to get the money as it's available and get as much as you can.
All right, let's talk some tenant challenges on some of these things. What if the tenant isn't paying even 25%?
So according to the state law, you could then file for unlawful detainer because they're not in compliance. City of LA, I would wait. I wouldn't do it right now because the city of LA, it's really like a pure moratorium. But in the countywide, so like we're looking at it right now in cities outside of LA County specifically, where people are paying nothing and they're not participating in the program. We've followed the instructions, the 15-day notice to pay or quit every month, been updating the numbers, and finally we're now going after the eviction.
That's certainly one option, but what if somebody's like, but wait a second, they haven't been paying for like 10 months. I want to get some of my money. There's this program to help me.
Then you approach the tenant, and you have to ask them to fill out the COVID declaration, which hopefully they already have. You have them fill out what's owed, and then you have to approach them and say, what we were able to do successfully was approach them and let them know, look, if you don't pay and we can't get you into this program, you're going to have this large consumer debt looming over your head July 1st of $40,000. If you owe that debt, it'll show up on your credit report and you won't be able to restart your business, unfortunately, because it'll affect your credit. And we encourage them that way, is the long-term effect on the credit, as well as, if you're not able to pay in July, then August 1st, if you get evicted, that also shows up on your credit. So we were able to encourage people. She actually wrote the check about 5 weeks ago when the program was announced, but before we had applied for the 25%. So she had some. I know she had no income, but I think she was able to take it out of savings to make it work.
So it sounds like there, at least as it relates to encouragement, there's a way to maybe get the tenant to consider how it's mutually beneficial for them to get that application in.
We were also just able to use that as well, and the benefit of like, look, we're trying to work with you here to get a very reasonable cash for keys buyout, under $12,000 in LA RSO.
That's
really nice property, like big $3,000 a month rent under RSO, like big property. It was actually really nice, and we got a pretty good deal out of it because we were like, look, we're going to let you go. We're going to give you your security deposit back. We're not going to charge you. We're not going to chase any money, etc.
Well, I don't know what you're charging, but it certainly sounds like you're worth it.
I appreciate that. Thank you. And it was for a tenant that was actually, as soon as we got the cash for keys signed, they listed the property, they got an offer, and Justin, you're now working with said tenant on finding their up leg for their 1031.
Well, we'll talk about that in a minute because I think it's an option that more and more people have started to consider and really is kind of win-win in today's marketplace. Does the tenant need to reply to a notice of missed rent every month or just one time?
We are asking for our tenants to recertify every single month from a documentation and paperwork standpoint. In case we are ever audited, we are asking for people to recert. And at least if they don't recert, we want proof of service that we did send it every month in case we're asked. So I would say it's a good practice to make sure that you do it every month. Also, Justin, by the way, before we go forward on that, if you do have tenants that start paying rent all of a sudden, remember under SB-91, a rent paid in April first covers April's 25, May's 25, June's 25%, and then it can cover the full April, the full May, the full June. Tenants have to give you their consent to apply money paid now towards back owed rent. So just because somebody pays and they didn't pay you in September, besides potentially making it the 25%, you can't, without their permission, apply 50%. So,
but you can apply the whatever they give you now to at least 25% back rent.
After you've applied it to 25% forward, and I would still get their permission to do so. But if you tell them that that's how they're eligible for the program, they shouldn't have a problem with it.
All right.
Some places are looking at rent paid in a gross perspective, like a 100,000 foot level. So if my rent, I paid it 2 months in full over an 8-month period, they're saying that that's enough as well. So
okay. Awesome. Hey, what we'll do right now, we're about 25 minutes into this, and we wanted to make sure, since we spend probably a fair amount of time on the multifamily issues, to talk a little bit about the issues facing commercial owners. Keep the questions coming in regarding SB-91 and multifamily. We will get to them before we end today, so certainly keep them coming. But let's talk a little bit about the commercial side. So there's been eviction moratorium across the state as it relates to residential property. And, last month we finally got some clarity on how owners were going to be able to recoup some of the money that has been lost or that has been tied up, as you couldn't evict somebody who wasn't paying. What are we seeing on the commercial side? And talk a little bit about the commercial eviction moratorium that's currently in place and how long that's going to last.
So right now, it depends solely where you're located. In outside of LA County, we have filed. I told you this, Justin, and you were kind of shocked by it, but it was true. So I have a client that owns about 25 large shopping centers. Think like Irvine Spectrum style, or Americana at Grand style up in Glendale. And we filed in 1 week. Outside of LA, we filed 187 unlawful detainers on commercial properties across the 25. None were except for 1 or 2 gyms for large anchor style tenants. All were for much smaller tenants that made up 2% of the overall space, 1% of the overall space, 3% of the overall space. But we've already started the eviction process. Outside of LA, for the most part, there is no protection for commercial tenants. You can start the eviction process, start getting them out. You can call on guarantees and letters of credit if needed. It is now fair game to pursue the properties. So,
for those in LA, they're still a little bit handcuffed. Talk a little bit more about that. Certainly, LA, San Francisco, Oakland, the larger cities have varying degrees of who you can get out.
Yeah, so LA still has its commercial eviction moratorium in place, at least until June, because the way that LA operated was they had a across the board eviction moratorium, and theirs was more stringent than the state's. And then when the state extended under SB-91, LA proceeded to extend all of it. In San Francisco, it has to do with value of the company, size of the company as it pertains to like market cap, potentially number of employees. So like if a PetSmart's not paying, you can evict them. But if a mom and pop or a smaller business isn't paying, they're more likely to be able to stay at least until the end of June.
All right. Any opinion or thought on whether that'll get extended?
I don't see how the commercial one can get extended. I think that there's a chance in some small places. I don't think LA will extend it. I don't think San Francisco will extend it. The market's coming back too strong. I mean, like I saw the CPI for March, which plays into 1482 rent increases, and the CPI for March was almost as strong as the January, February CPIs of last year. And the stock market, everything's doing really well. I could see certain cities like Los Angeles, San Francisco probably potentially extending eviction moratoriums on multifamily though, but not. I think it's going to be a free for all on commercial properties.
All right. We've talked before about how you get maybe somebody out on a residential property when there's eviction moratorium. How do you do it on commercial?
I think it's the same way that we've approached some of the residential items recently as well. If you need the money, want the money, and think the people have it and are going to chase it, there's one approach which we can talk about. But if you don't think the people have it, it might be a situation where you say, look, we aren't going to chase you for the back owed money. You've kind of already written it off. If you leave now, we won't chase after it. Just give us our property back. And that has been working for us in certain situations where we just approached them directly and said, look, we're going to be forced to chase after you. We know you don't have it. If you give us the space back, we'll let you go. And it's kind of like it's a lease settlement agreement. Essentially, it's a lease cancellation settlement agreement. It's pretty easy to do. If you think they have the money and you want to chase it, then you just have to be patient and wait and get ready and file the UD and then pursue any letters of credit or guarantees as soon as the moratorium is lifted.
All right. Talk for a minute. We'll get into maybe some other legislation that's out there. I think you and I both have been saying that we couldn't envision when there was going to be a landlord favorable bit of legislation coming, and it appears that we're still not there yet. Talk about AB 255. Some people might not know that one at this current number, but they might remember it as AB 939 last year and what that looked like.
Yeah, so AB 939 was the proposed commercial eviction moratorium at the statewide level. I think the thing that scared people the most, if I remember correctly, Justin, about 939 though, was that if somebody was willing to pay, like I believe it was 3 months of the rent owed, they were able to get out of all personal guarantees, all letters of credit. All of those items were going to be forgiven under that bill. That was everybody's fear, was all of the landlords' fail-safe protections were being gutted in the bill. It wasn't just about not being able to evict them, but really what it was about was all your security interest was gone. It was essentially a free pass for a tenant to leave with minimal damage.
Yeah, and I think that the other part about 255 that is important is that, yes, there's a lot of probably credit tenants out there, but there's a big portion of mom and pop and small businesses, individuals that occupy a lot of the commercial space up and down the state, whether it's industrial, office, or retail, that 255 would allow the tenant to stay in the property, or the eviction moratorium for non-payment of rent to run through August of 2022. And so that one, certainly from an income stream standpoint, I mean, we've got, Jason and I share a couple clients who have made zero or close to zero from their property over the last 12 months, let alone having to be stuck with it for another 16, or in certain instances where people have sizable loans, certainly could be a big issue. It ended up getting 939 got gutted last year, and then ultimately didn't go anywhere. But this seems to have a little bit more momentum. What do you think its prospects are? What are you hearing about it? Any additional comments?
So normally I don't think things like this are going to pass. I tend to be optimistic. I do realize, though, the more that I sit here and think about opportunities and think about what's going on, there's a lot of capital that was raised sitting on the sidelines to buy distressed opportunities. So if I was one of those large funds that was sitting on billions of dollars to buy distressed deals that haven't fully showed up yet, I would be in support of something like this because it's more likely to create a bunch of distress within the market and give me an opportunity to buy. So I think you're going to see people that wouldn't traditionally be lobbying for this to be lobbying for it. But some of the large institutions like the Irvine Company and others, they'll be lobbying against it, although I'm sure that many of their tenants are still paying, at least in the office buildings. All of our the office buildings here are still full. So we'll see what happens. I know there are some vacancies down at like places like Fashion Island and whatnot that weren't there before, but we'll see how it plays out. I do think that there's a better chance that this passes than 939 does or did.
All right. I think the other one that people need to be kind of aware of, especially if you own commercial property, is 71, which would just make it more difficult for businesses to operate in the state of California. And we can continue to see more jobs and businesses leave every day. And I think that, you know, as a business here or there goes, it doesn't really affect anybody or we think about it. But really, at the end of the day, with all of our commercial property, if there's fewer tenants, that means rents aren't, you know, you're going to have more vacancy, which means lower NOI. You're going to have less ability to increase rents over time, which are all the things that affect the value and ultimately whether it makes sense to continue to hold the asset or if there's not better options. So owners banding together, whether it's multifamily issues or commercial issues, but all private client investment real estate owners banding together to protect some of these things that allowed their properties to have gone up as much as they have over the last 20 years, or for the rents to grow at such a significant amount. I mean, historically, we've always talked about how California, from a value, from an appreciation and a rent growth standpoint, typically outperforms other markets. That may not be the case to the degree that it was years ago because of previous legislation. But if we continue to see more legislation that is negatively impactful to the properties and their ability and the strength of their income stream, we're going to see a continued erosion of that appreciation and of rent growth. To that degree, you and I were right before, you know, getting onto this call, going back and forth about AB 1199. Maybe for our little legislative review, that's the one we'll finish on. You want to talk about that? Give everybody a couple quick highlights and kind of what you think it means for a property owner.
Oh man. So I just got this today and I was reading through it about an hour before we all met. And the line that caught me was on the top of page 2 of the bill. And I'm just going to read this word for word. And there's one word in here that I will reiterate a couple times that is just unbelievable. But it says the bill would impose an annual excise tax upon a qualified taxpayer as defined for the privilege of renting or leasing out a qualified property that the taxpayer owns in the state of California at a rate of 25% of the gross receipts of the qualified taxpayer as derived from the rental income. So 2 big things. One, they'd like to tax you 25% of whatever you receive as rent off the top. And they're letting you know that although you worked hard, earned your money, and invested it in real estate, it is a privilege to receive rent. It is not a right anymore to receive rent for your property and to rent it out. It is now a privilege to receive that rent.
I'm going to let it sink in because when I read it today,
I
almost makes you laugh. You're like, I can't believe it.
I was speechless. I looked at it and I'm like, if this passes, there's no incentive to ever own a property in the state of California, because if you think about it, if you buy stuff at a 5 or 6 cap rate and you bought it at a 5 or 6 cap and that's what your loan's based off of, but now we're just taking a 25% haircut off the top, you're not making enough to cover your debt service, let alone make any money.
Well, I'll do the math real quick for people. If your income is 100%, you take 25% off the top for the privilege tax. You take 5% in vacancy. You got, let's call it 30 to 35% in expenses. If you went out and got a loan at, relatively market rates and used leverage, that's another 30 or 40% of your income, and you're making $0. So the only way that somebody buys a property is if they're priced a lot differently than they are today.
Right.
And, it's interesting. I'm not sure in 1999 when I got into this, I thought I'd see 5 caps for buildings, because when I was selling multifamily in Long Beach, when I just started out, I was selling buildings at 4 3/4 a gross rent multiplier and caps of 11 or 12. As these taxes or inability to increase the income stream continue to mount, the numbers get affected. And that's where, Jason, I think over the last year, with a number of the clients that we've had the privilege of working together on, because these clients that go out of state need expertise on lease, on, purchase agreements when they're out of state and whatever, and we've had the good fortune of doing it, is that people are really considering it now because it is a different environment and they can make a significantly better amount of money in an easier scenario than what they are experiencing in California over the last few years.
Yeah, and Justin, it's not just a significant amount more, but it's a lot less stress. Like if your tenant is Starbucks and you just get your check every month, or Chipotle or CVS or Walgreens, it's just we don't have to worry about these, right? Like the lease covers if things change, because guess what? The tenant pays for all of it. And so why don't we, if you want, take a couple minutes right now, and I know we're going through some deals together. Do you want to talk a little bit about some situations that we've seen with clients in California where they were able to sell their building, whether it was producing income right now during COVID or not, and exchange it into an opportunity where they substantially increased their cash flow, lowered their risk, and in reality gave themselves a better quality of life from a management and stress perspective?
Yeah, I think we'll walk through a few things. And I know that there's just some questions mounting up, so I'm going to try to be quick. But what we did decide to do today was put together a couple sample scenarios, because for everybody who's been to our events pre-COVID and been on a lot of these calls, have heard us talk about some of these opportunities that we think were available, and certainly they still are today. The first one I'm going to give you an example of is there is an apartment building. It says, if you can see the screen, it says the purchase date is 2004. Jason, I'm not looking at the screen, but can everybody see it? Jason,
it's going up right now. Yep, it's up.
So, little story, back when I was much younger and much thinner, I sold this building in 2004 for $2,250,000. The buyer put $720,000 down. It was an environment where there was no rent control. They were in their early 40s. They were in growth mode. And if they wanted to get somebody out, and this building at the time needed a little effort, 30-day notice and they could get somebody out. You can see on the right-hand side some of the numbers. And what I really want to focus you on is in the middle section, their after-tax net cash flow was $33,903, which was a little under 5%. And there was some upside in that property. What I want to do is fast track you now to what those numbers look like, because we talk to a lot of owners that today say, I can't make any more money. I'm making too much money. And what that usually means is they're looking at their return on their down payment. So today, 17 years later, this property at 765 Cerritos is worth almost $5 million. The owner there's making more cash flow today than ever. Rents have basically doubled since then, but there is rent control. There are eviction moratoriums. If you own buildings in Long Beach, water is now priced like gold. The client has moved into preservation mode now that they're in their late 50s and early 60s. California's gone from being a landlord-friendly state to a tenant-friendly state. And they go down to that after-tax net cash flow number and making $90,000 now. 2 times, maybe 3 times, I don't even have the number in front of me anymore, than they made when they originally bought the property. And they go, I'm making so much, I could never make more. And you can see that 12.58% next to it. That's their return on their down payment. But what most people are missing or realize is they're really, go to the third one, is what they're really making. Because today you can see that equity number on the bottom of the third slide is $3,389,000. That's how much of their equity is now in the property. It's not the 725, it's all this equity that they've built up from the years of ownership. They're making less than 3%. We all know that we've spent the first 40 minutes of this talking about how difficult it is for landlords. And there's a threat of repeal of the 1031, or at least conditions on it. I'm going to take you to that number on the after-tax net cash flow. They're making that same $90,587 that I showed you on the previous slide. That is a 2.67% return on their equity. This is where we get more owners to consider their options in light of how difficult it is to own and operate property in California. Because when they really look at that, they can do significantly better on the equity. Our team loves to put together these analysis. I'm going to show you two properties right here. The first one is a multifamily property in Colorado Springs. And you might say, well, it's Colorado Springs even, rents don't go up, buildings don't appreciate. I'll get back to that in a second. But if they use their $3 million to buy an $8.7 million property, day one, they make $101,000 in cash flow. And over the life of ownership, over 10 years, they'll make over $1.5 million more by owning this property than owning their building in Long Beach. Now, somebody who might be in capital preservation mode and wants nothing but ease because they want to drive their motor home, they want to spend time with grandkids, they don't want to deal with it, can get a triple net leased investment, which Jason loves. If you ever talk to him, he will talk you into owning a triple net property. This one's listed at $6.7 million. They put their $3 million in and they get almost $16,000 in income to do nothing but look at their bank account online. Now, that's one option. That was apartments. You might say, well, what about commercial? We'll get to it in a second. Camille, real quick, if you can pull up the Colorado Springs, because the thing we hear all the time is, well, California appreciates. Well, California's rents grow. All those things were true before we had a lot of these impediments and hurdles. I'm going to show you three properties. You ready? The first one, as you can see, in May of 2014, sold for $11 million. In December of last year, it sold for $29 million. The average annual appreciation on that property was 9%, and the average annual rent growth was close to 6%. The next one, a little bit smaller building. You say,
Justin, really quickly, just to point out, under AB 1482, you're capped at 5 plus the CPI on rent growth. Anyways, last year the CPI was 0.7. So keep that in mind.
Yes, and Jason, when we track the numbers, very rarely in any 10-year period do rents grow in Southern California at 6% or more
right.
on an annual basis over any 10-year period. The next one's a little bit smaller property, sold for $575 in March of 2014. 7 years later, $1,460,000. That's a 7.5% growth rate on appreciation and almost a 6% growth rate on their rents. And the last one, so you can see that in a market like Colorado Springs, one that Jason and I have been talking about for the last year, is where we see opportunity because of the demographics, because of the education, because of the industry. Annual appreciation at just under 9% and rent growth at about 5.15. So that some of these growth markets across the country don't perform like California is maybe a bit of a myth these days. The next one we want to show you, and I'll get this done in 5 minutes so we can get back to our questions, is the commercial owners and the position that they're in. We work with a lot of people that they bought a building for their business. They've operated their business for years. They're now looking to get to retire. And so here's our example on this. This is a property purchased only 8 years ago down in the industrial part of Huntington Beach for $1,475,000. Owner put 10% down on an SBA loan, and they bought it to operate their business. Now today, 8 years later, they're a little bit older. They're ready to retire. They're going to sell the business to the employees, but they're going to keep the building. The property today, vacant to an owner user, is worth about $2.9 million. But if they rented it out, they'd be able to get $120,000 a year. They still have those loan payments. Their cash flow would be about $50,000, but after taxes, Their after-tax net cash flow is $38,619, which is a 26% return on their $146,000 that they originally used to buy the property, their down payment, but it's not that return on their equity. Their return on their equity, if they keep the property and rent it out to that business, is a 2% return on their money. Oftentimes for owners that have bought a property for their business, it's better to sell the real estate to an owner user and then put the business in leased space to maximize the value of the business when they're ready to sell it. But in this case, it's only 8 years. Now they're making 2% on their money. What could they do? We got two examples for you. It's a $3.5 million Sherman-Williams, which is one of a corporate guarantee, highly rated tenants. It's a 25% increase on their income, close to $50,000, up from the 38, again, with nothing to do, and a big corporate backed tenant. And then our other option, for those of you that have got kids, grandkids, whatever, or you really like chicken fingers, Raising Cane's, which is probably the in and out of the 80s. This one's in Mississippi. I showed this property to Jason, I think yesterday, and he was like, that thing is awesome. And I agreed. For $5 million, they'd end up making $70,000 on their equity, which is an 80% increase on what they could do by renting it out to the tenant. So,
Justin, as a reminder, the best part of these is you go to the mailbox once a month and collect your check and go deposit it at the bank, and that's all you ever have to do. Like,
first one I ever sold was a Burger King in Lima, Ohio. The lady who owns it, her name is Winnie Allen. She's looked at her bank statement online for the last 15 years on the 28th of the month, and her check is there. They really are great. And we would encourage anybody who's A, little fed up with California, B, you're in capital preservation mode and you'd love to make more cash flow easily, to just explore the options today. In my 20 years, whether it's in-state or out-of-state, because truthfully, for every owner that is fed up with California or wants more cash flow, there is an investor that they're good at getting tenants out and increasing values of the property, or they're trading up from a small building and their life is here and they want to own more of California real estate. There's win-win opportunities for people. All right, Jason, we got 11 minutes left and probably 24 questions.
Let's roll through them.
Is there a cap on how much money you can get for each unit with relief?
Technically, no, but the cap is 80% of the back owed rent. So whatever the back owed rent number is. Now, remember, the people have to qualify under 50 or 80% AMI. So you're likely not having someone that's renting out a place for $20,000 a month that would qualify and owe you, $150,000. But no, there's technically no cap. It's just when it runs out.
Yeah, I would think that your $3,000 a month tenant is the rarity at that sort of rent level. Doing a little bit of numbers on our end, we think that if they're making more than $1,800, if they're paying more than $1,800, they are going to be the last priority list that would get any money.
Yeah, we did get lucky because she totally, unfortunately for her, she ran a business. The business went to zero when COVID was over. She ran a business where she rented out homes and then sublet them in by room basis to college students, and college students weren't staying in lodging, so she had no income.
We already talked about this, but quickly answer it for who asked. Are applications reviewed based on when received or on income of the tenant?
So 3 levels. First, they're applying in order. So 50% AMI, areas hardest hit, and then 80% AMI. So those will be the first. And then it's generally in order received, except for in Los Angeles. Los Angeles is doing 50% AMI. The assumption is LA as a place was hit hard on its own. So it'll be 51st, 82nd, but they're doing a lottery at the 50% level. So if there's not enough money to even cover everybody at 50%, it's just who got picked out of the lottery. And we were lucky enough, like I said, that our application did get picked. Although I don't know if we got picked or there was just, 1,000 applications and they had enough money to cover 1,000. So they took everybody.
Well, based on the first poll, only 2/3 of owners have replied. So here's an interesting question about Section 8. Does Section 8 payment enter into the calculation for the 25%, 80% owed, or 80% paid?
So there's multiple kinds of Section 8. It depends if you're so there's voucher and then building contracts. Either way, the Section 8 payment covers either a portion or all of the rent. If you're getting all of the rent, you're not going to owe anything. If you're getting over 25% from the Section 8, then technically the tenant is in control of the voucher. So I would say that yes, the payment counts towards the 25%.
What if my tenant paid more than 25%, but stopped at 25% for the past couple months? This is exactly what I said was going to happen. Is if people were going to realize they
this
only
is exactly what you said was going to happen. If the 25%, if the amounts paid so far total more than 25% to date, then you can't. Then they're in compliance. So most places like LA, for example, is looking at it in a totality. So the tenant that I was explaining in our situation, she wrote a big check, she wrote like an $8,000, $9,000 check, $10,000 check, whatever it was, and it covered a handful of months. But we were told that we had to apply it going forward first to make sure there was enough to cover the 25. That's why it's really important to have someone that knows the rules, do your calculations on your paperwork so you don't get it wrong.
I'm going to get to my shameless plug for you in a second. Can we confirm the moratorium says if tenant can't pay, they don't have to pay 25% until the end of June?
Yes, that is how it is being interpreted, but that does not help you for the application process for the SB-91 relief. But the way the law is being interpreted right now is if they pay you on June 30th, a check for 25% from September 1st to June 30th, the court will look at it like they paid the 25% for the whole time.
Thank you. And now I'm going to give everybody my plug for you, because the next question is going to end up being about getting somebody out and cash for keys and those sort of things. And certainly, I think I said it in 2018 that every bit of legislation I thought was targeted to make life miserable for mom and pop landlords and would benefit the large institutions, REITs, et cetera, / I guess the state in their acquisition of private property. And that is certainly the case. And so navigating all this stuff and knowing what to do, I think, is critically important to keeping your income stream secure. And one of the thing that I most enjoy about working with Jason on transactions is the creativity to find the ways to make things, to still get things done the way that we are used to in light of new legislation and the new challenges in place. I would say once a week, maybe once 2 weeks tops, we'll be talking about an issue and he'll be like, oh, on that one, this is what we figured out we could do. And now that's what we're helping this person get around that, or do whatever it may be, or get this person out. We've got a challenging situation where somebody is not only way behind on rent, but super difficult and is almost baiting the owner to do something wrong. And the creativity that Jason has shown to help the owner deliver the unit vacant so that then the owner can maximize the value is worth its weight in gold. So that's my shameless plug for you. My next question that everybody wants to know. So if cash for keys is an option, Jason, is there any sort of agreement you give the tenants that's really protective? Like, has anybody come up with a really good document?
We have one because we do it all the time. So yes, we have a really great cash for key. It's actually a lease buyout agreement or a lease settlement agreement. And then depending on where you're located, there's some notice forms and stuff that we have to fill out and serve to the tenants as well. In a process we have to guide them through, but we do have a very good contract that is extremely protective, but not too difficult to understand for someone reading it. I mean, we have some non-sophisticated tenants that have read it. And we do have people, we haven't had to do it yet, but we do have people, you're supposed to deliver these notices and the contracts in the native language of the individual. So we haven't been asked yet, but we have the ability to translate it to Spanish if need be. So far we're looking at doing that just as a precursor.
Thank you. Oh, hey, we talked about this a month ago, but it's probably worth talking about again. What happens if you had a tenant that was way behind and they bailed on you in February?
Then they just walked out and left.
Yeah, they just walked out and left, but they hadn't paid 5 months worth of rent.
Oh, now so then that rent that was owed has been converted to consumer debt. On July 1st, you can go after them for breach of contract and the money. And then also on July 1st, and that's going to be through the small claims court process. So you don't need a lawyer. The only thing a lawyer can help you do is draft the paperwork, which takes about an hour or two. And then you get to go represent yourself. We can prepare you for that. And then you can always sell that consumer debt judgment to a claims company and let the claims company chase them. And you get a percentage on the dollar, or you can chase them yourself.
So we've got a bunch of questions about the whole 25% thing, and people they don't have to pay it now. They can wait and pay it in June. My question for you is, let's say that they can't pay it and they don't pay it, but they're going to pay it in June, and they don't pay it in June. What can I do?
So the first thing I would do is make sure you get the tenant to sign the COVID-19 declaration. Failure to sign that within 15 days of certified delivery is grounds for eviction. So if somebody's not willing to sign under penalty of perjury that they don't have the money, that'll be something nice to have in your arsenal as like a backup if you have to go after it. So that we found a lot of people when they realize it's under penalty of perjury have either paid or filled out the paperwork and then filled out the paperwork and paid. So that's something to let them know. And in the meantime, though, I think, you go after them starting on June 30th for July 1st for the full amount owed of money, breach of contract. And that's all in small claims court. Like I said, it's $100 filing fee. We can help you fill out the paperwork if you need it. And it's just you versus them unprotected. All you got to do is walk in with the lease and say, I never got paid. It should be pretty quick.
But I'm just talking about the 25%. So they say they can't do it. They fill out all the forms. I get my 80% of the 75%.
Right. And then they say that they all of a sudden on June 30th, they don't pay you that 25%. Yeah. You go after them and right away for breach of contract. Also, you could actually probably file right away for eviction because they weren't in compliance with SB-91. So if they didn't pay you by June 30th, you could file for UD on July 1, which would be a huge deal because there's going to be a big application for evictions likely August 1st, which is all the people coming off of SB-91 that did pay 25%. So if you could get yours a month ahead of schedule in the line, it would be pretty helpful.
What is the application process after we submit the app on behalf of the tenant? And how soon should we expect to receive the funds?
So after you submit it on behalf of the tenant, there's going to be another round of paperwork that gets sent back. It's a lot of like specific questions for you and the tenant and verification. I actually filled it out on behalf of my client, and then I worked with the tenant to fill out their portions correctly. Oftentimes that's where the rent owed numbers come into play. And then from there, we had 10 days in LA to resubmit the second round of application paperwork. Ours was due tomorrow. We got it in, I think, yesterday evening or Monday night. I forget which one. And then I believe we should get a check within 30 days.
All right. And every time we have one of these legislative things, you provide this opinion, but I'm going to ask you the question. With regard to the 25% privilege tax, is this not a constitutional infringement and overreach by government?
I don't want to get too political. So first off, there's like the Boston Tea Party, no taxation without representation. But no, look, they can raise taxes however they want. It's our job to vote people in that support it or don't support it. I think the big argument here would be a regulatory taking, not a regulatory overreach. And by regulatory taking, what I mean is that because of the items passed by the legislature, they've essentially taken your property away from you and made it impossible to operate it. They'll have made it really impossible for nearly everybody to operate it and make a profit. So they're taking everybody's property away through a foreclosure proceeding potentially, or a tax lien issue, based on the fact that you can't afford to operate. So that would be the argument.
On every one of these things, when this question gets asked, Jason provides the same thing, that there is an argument that would protect owners, whatever, and most of these things still get passed.
Well, the other thing to keep in mind, Justin, is if it gets passed, it'll get appealed and it'll take 2 years to go through the appeal process. So in the meantime, if you're nervous, you can list the property right away and get out. But I would say, look, if this is something that scares you, or the whole operational items are what make you nervous, sit down with your advisor at Centennial and talk to them about your portfolio and what you have, and maybe some diversification, and looking to move things around. 1031 still exist. There's been renewed talks recently that they might go away or have some really, really strict limitations on them. So why you can do that now, do it. Before California does anything even crazier, look at it. And I've had a lot of clients that were just, man, I'm so happy with what I have. And we sat them down with Justin or the team, and we showed them the analysis like we showed today on the screen. And people were like, man, I didn't realize how much I was missing out on. Right? Or I didn't realize what I didn't have. Or, oh, I didn't realize how little my favorite. I didn't realize how little I was making on my actual building. Like, that's the one that got me, was I didn't realize how little I was actually making on my building. And then they see how much more they can make, and life will be a lot better.
I want to thank everybody for attending. We will include Jason's contact information as well as mine at Centennial, which I will happily get you in front of the right advisor for your particular asset, as a part of our follow-up thanks for attending email. If anybody has feedback, additional topics you want us to discuss, please, when you get that email, share it with us. We do our best to come up with things that we think will be valuable to owners and share as much good information as we can. Jason does a tremendous job on all of the legal issues and challenges that owners face. And we hope more of you will take advantage of what Centennial can provide in analysis and expertise to help you make sure that you are making as much money as you can easily, in light of all the things out there. It's been another great session. Jason, thanks for all of your or maybe as a part of an additional recap on the playback. We'll get to those questions as well. But thank you very much. We hope you have a great day. Please reach out to us if we can help in any way. I know I speak for Jason when I say that, but for everybody at Centennial, we'd love to help you make the most of the.
Thanks again for having me, Justin. Appreciate it. Froze.